Hey, everybody. Thank you for your patience. We're waiting for half the committee is in the House right now, and the other folks are coming in right now. So we'll start as soon as we have a quorum. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, April 2nd, 2026. We have 15 bills on the docket. We're going to start off with Delegate Griffith and Senator Zucker with House Bill 980.
All right. Thank you, Chair Smith, Vice Chair Walstreich, and members of the committee. For the record, my name is Delegate Mike Griffith, and I respectfully request a favorable report on HB 980, Family Law, Human Services Guardianship Assistance Program, and the State Foster Youth Ombudsman, otherwise known as Kania's Law. It's been pretty well documented. Back in September, a foster youth named Kania Ward took her own life in the custody of a vendor that the state had hired to provide services in a hotel room in Baltimore City. A significant tragedy for a variety of reasons. The mother of Kania voluntarily submitted her daughter to the care of the foster system because she was suicidal, repeated attempts of committing suicide, and unfortunately this vendor allowed her to have very little supervision, even checked on her twice after she had taken her life, and then finally discovered 5 hours later that she was dead. Failures at multiple levels of the system that led to this. The bill as originally introduced include prohibitions in unlicensed settings, but we worked very closely with the Speaker's bill, and we moved that provision into her bill. We also worked very closely with the Governor's office as well as DHS on amendments on the House version. We accepted those amendments, and now both the administration and DHS are favorable to the bill as introduced here in the Senate. So what this bill does, as amended, it codifies a program which allows for background checks for guardianship homes, because within the DHS audit, they identified multiple individuals that were placed in guardianship homes with sexual offenders, and some of the children were unfortunately abused in that scenario. So this will require those background checks for individuals with guardianship homes. Also, it creates a state youth ombudsman position within DHS. This position also created 2 layers of protection to make sure this is individual that is independent of the secretary, to make sure they can properly advocate somebody who must be an attorney. And before this person can be disciplined, they must have a hearing as well, which will also create more protections to make sure this individual is an independent advocate to make sure these kids are getting what they need. So a lot of work, a lot of collaboration's gone into this bill. On the House version, we had co-sponsors from every part of the political spectrum. And again, the amount of support and conversation that we've had with this has been overwhelmingly meaningful, and we're grateful for it. I'm also very grateful for my cross-file Senator Zucker, who's also been a champion for our foster kids for a long, long time and has been willing to support this effort. I'm happy to take any questions, but with that, I would urge a favorable report. Thank you.
Thank you very much, Mr. Chairman, Mr. Vice Chairman, distinguished members of the Judicial Proceedings Committee. For the record, Senator Craig Zucker, here to support not only House Bill 980, but Senate Bill 996, which is the exact cross-file. Mr. Chairman, I join the delegates. I really join all of us to demonstrate that the foster youth population are our children, and we'll fight like heck for them like they're our own. I also wanted to demonstrate that this is not a partisan issue. This is a Maryland issue, and party politics has no role in this, and it hasn't had a role in this. I appreciate the delegate's strong leadership. I appreciate the administration's leadership on this, and I wanted to salute and thank Kania's family, who showed unimaginable courage during this difficult time. And with that, I would ask for a favorable report, Mr. Chair and colleagues.
Excellent. Thank you both very much. And we'll turn over to the committee for questions. Senator Walstreich.
Thank you, Mr. Chair. Delegate Griffith, thank you for being here. Some of us have not had the privilege to serve with you, and so the press about this has hinted at a personal story. Absolutely no obligation to share, but I'm curious if you would like to share your personal story.
Thank you for that. I know. So I was a foster child. I was in the foster care system from the ages of 12 to 18, and I talk a lot about that. My experience in the foster care system My worst experiences were with my foster parents. It was with the system and the problems that existed in the system, to age myself 30-plus years ago. And so these issues we're tackling aren't tied to an administration or to a political party. These are systemic issues that have been deep-rooted throughout the foster care system for my entire life. And so I'm very fortunate to have the opportunity to be able to join Senator Zucker and others in tackling this and finally bringing some real progress to reforms within the system. And that's what this is. This package of bills, my bill, the speaker and my bill, these bills are the first step of substantive reforms. The governor and the Public Works passed, Board of Public Works passed a resolution to fund identifying more beds and more opportunities for housing. We're working on legislation next year to generate more foster homes, not just more beds. So again, I guess I didn't go too much of my situation. It's not. I guess my best answer is yes. I was a foster kid. One of the reasons I joined the Marine Corps was to get out of the foster care system. I enlisted at 17. But this isn't about me. This is about Kanaya and these other kids that are dealing with this right now. And the past is the past. We can change the future right now. So, thank you.
Okay, well, Delegate and Senator, thank you both very much for your work and obviously bringing all the stakeholders together to produce a really good, quality, refined product, but also a great example of how we're different than a lot of the national politics. So putting partisanship away, working together, getting some good stuff done. So my compliments to both of you. Thank you both very much.
Thank you. Thank you, Mr. Chair. Thank you, Committee.
All right, with that, that'll conclude the hearing for House Bill 980. We'll now move on to Delegate Cardin with House Bill 1345.
Mr. Vice Chair, members of the committee, for the record, John Cardin here asking for a favorable report on House Bill 1345, and thank you very much for your indulgence in taking me first. I do have to get to my family for this evening, and I really appreciate that. This is a relatively minor bill, and it is not. I will have another one that'll be a little bit, maybe have some longer conversations tomorrow. But House Bill 1345, for those of you who don't know what interim clauses are, I will just quickly go through it. If there's any questions, ask them. If not, I think it's hopefully self-explanatory. It addresses an issue commonly referred to as no contest clauses in the context of estate planning and trusts. These clauses are designed to discourage beneficiaries from challenging a will or a trust by threatening to disinherit them if they contest a document. Maryland law already recognizes these clauses can chill legitimate legal challenges, which is why Section 4-413 of the Estates and Trusts article provides that if probable cause exists for instituting proceedings, a provision in a will that penalizes a person for trying to create or question something in the will would be deemed void. That those interim clauses would be deemed void. However, the same protections does not currently exist under the trusts in trust under Maryland Trust Act, and House Bill 1345 addresses this inconsistency. The issue was brought to our attention. Actually, it was Delegate Taylor's resident and friend, Michael Harris, whose family had been involved for more than 4 years in litigation surrounding a family trust. For Mr. Harris, the trust was significantly amended just 3 months after the death of his wife's grandfather, dramatically shifting control of benefits to a single relative who had not even been included in the original trust created when both grandparents were alive, actively engaged in their estate planning. Despite the serious questions surrounding the validity of the amended trust, the case was ultimately dismissed because the challenge was not filed within the 1-year period specified under the Maryland Trust Act. The court interpreted the provisions as a statute of repose, meaning that the case could not proceed regardless of the underlying circumstances. As a result, the court never reached merits on this dispute, which is why we're here today to try and make sure that this doesn't happen the next time this comes up. This highlights this real-life example highlights this. So first, it addresses the inconsistent treatment of no contest clauses as a Maryland policy that's long recognized that individuals with probable cause should not be penalized for raising that probable cause in a trust document. And two, it reflects the broader concerns that ensuring that Maryland's trust laws do not intentionally prevent legitimate challenges where fraud, duress, or undue influence have occurred. Maryland courts have already the authority to review the trust administration documents, intervene where necessary, and prevent abuse of discretion by trustees. And 1345 reinforces this. I will tell you that I reviewed this with the MSBA, who found this to be perfectly fine. This is not one of their priority bills, but they see this as an appropriate measure. And then I do have a list, which my intern put together, of what all 50 states do with interim clauses. And Maryland is out of the ordinary. We're I think one of two or three states that doesn't do this for trusts, but we would be perfectly within reason of about 46 other states if we do put this in. If you want me to specify what this does for those of us who don't practice estates and trust law, I'm happy to go into further detail.
Thank you very much, Delegate. Questions from the committee? Senator James.
So good to see you.
Good to see you, Senator.
I think we almost started together. Great, I mean, speed reading there, but great job, really, of explaining. I just want to clarify, because you're working so fast. So just so I understand, even if we are to get rid of these particular clauses, there are other codifications that do rein in if somebody is contesting in a frivolous or vexatious way. Is that correct?
That is correct. In fact, what it would specify is that you can't do it. These clauses would be enforceable if it was frivolous. It's only if there's probable cause that the court can determine they're unenforceable.
Oh, okay, I see.
That's the idea.
And just because I hadn't heard that term, I think I would have, probable cause, which is so normally you hear in criminal cases. Is this because generally these come up, these contests come up in those cases of fraud and duress, which are, right on the line, or actually are in criminal in nature? Is that
It could be. I don't.
Is that the term of art, or is that the term you're using?
I don't believe it's a term of art in the estates and trust world.
I didn't think so either.
I'm using it because that's how it's described. Actually, again, this is I don't know if it's from the National Conference of State Legislatures, but it's a description of all 50 states and what they do. And in there, they use the term probable cause.
I brought it up, and thank you, man after my own heart. That's what I would have done for this bill, looked at what all 50 states do. But that's why I'm asking. Probable cause is so, I do some estates and trusts, and probable cause I usually only see in more criminal cases.
Right.
So now would be adopting the term probable cause. And is that somewhere else defined in estates and trusts, or maybe when we did the will, you say we also outlawed these in some fact, or limited these with wills, not trusts. Did we adopt that probable cause terminology, and did we define it anywhere, or are we trying to hearken back?
So I believe in the
multi-part question, but anyway.
So I don't know. I will have to get back to you on whether it's defined in the article. But what is in the article is good faith, just cause, full enforcement, unenforceable clauses. And I maybe mistakenly am using probable cause, but I believe that.
So I'll let you finish.
Go ahead.
You wouldn't mind then if for some reason probable cause isn't quite the word we want to use here, if we would be more consistent?
It's the policy. It's the policy.
What we did elsewhere, and we captured the right language, so we're not mixing our areas of law between civil and criminal, perhaps?
No, if it's not the appropriate language, that's fine.
Okay, so
You're right. And Mr. Chair and members, it is not cross-filed, just so you know. This was something that came in relatively late. You can see by the bill number.
Oh, right. Well, good for you.
In that case, we should go ahead and vote.
All right, well, thank you, Delegate, and I love working
But it
with you.
it will have a meaningful impact on the trust world.
Happy to follow up with you, maybe we'll just change it.
Sure.
Thank you.
Interesting issue. Appreciate it.
Thank you very much, and thank you again for your indulgence.
Of course, and with that, that'll end the hearing for House Bill 1345. We're going to go on to Delegate Kaiser next with House Bill 1305.
How are you?
Mr. Chairman, thank you so much. I appreciate the accommodation. Mr. Chair, Mr. Vice Chair, good to see everyone. Good to see my high school classmate, Senator McKay. He's graduated a year behind me. He looks a lot younger. All right, do I have your vote? Thank you. All right. So I'm here about an issue. Honestly, we've all heard the words. This one is relatively simple. It's a bill designed to create a better data landscape for policies about foster youth. You heard from Senator Zucker, you heard from Delegate Griffith. There's so many colleagues that have bills dealing with foster youth, whether it's their education issues, health issues, there's issues obviously, in this committee and the Judiciary Committee. But one of the things I discovered when doing work in this area is how little data there is and how little good data there is. So it's really fragmented across agencies, difficult to analyze comprehensively, and that's what this bill is trying to put together. So right now you can get some data out of MSDE, you can get some other reports. You can get a report that I shared in my testimony, and the nature of the report shared by MSDE shows you things like retention and graduation and getting jobs and mobility and missing classes and all the rest. And they differentiate it by students between different grades and then gender and different racial categories. But then you look at this data and say, and? Kind of that, not the so what, because it's important, but the so what's next. And the challenge is that we don't have that comparative data. So what I'm looking to see, the first part of my bill is something pretty simple, is getting the data lined up, possibly just a 2-page report that looks at the highest level metrics and just compares kids in foster youth to kids not in foster youth. And that's where I think people will then notice these glaring challenges, and I think it will help elevate the issue. But this bill goes a little bit beyond that data request, because the data request is the easy part. We could probably get that done in another way, but the bill's doing other things as well. It's asking just for a one-time study to identify best practices from other states, needs and gaps in our services, and recommendations for improving data collection and reporting requirements. We are not doing a great job by our foster youth in this state. We have a lot of great programs. They're not always stitched together. A lot of kids fall through the cracks, and there's so much more I think we can do, and I'm so delighted to see so many colleagues doing it. And I'm just trying to create this data, better data so we can make these decisions. This passed the House with a vote of 128 to 8. I urge a favorable report. Thank you.
Thank you very much, Delegate. Senator McKay.
Chair, thank you, Delegate, for bringing this bill. It is true, I used to follow you through the halls of Rockville High. You were always with the cool kids. I was always
You might have me confused with somebody else.
You were always in the front of the class, and I was the guy always in the back.
That part might be true.
That may be true. But I want to say thank you for bringing this bill. I just want to confirm with you that there's no fiscal impact, and that with this aligns with the agency's capacity and that kind of stuff. And I think you designed it that way.
Yes, I did. Thank you.
To make sure that it's the data and how we drill down to it is important, not necessarily the cost therein.
Yeah, thank you. Yes.
Thank you.
No cost in this particular bill. Thank you.
Thank you very much. Before I ask a question, did this good senator behave well when he was in school?
I believe he did.
He does not here, I'm just saying.
That is hard for me to believe, Senator.
And let me just thank you for this bill. It's a good bill. I know a little bit about that, but it's a very good bill, and thank you for bringing it.
All right, thank you.
So good to see you, Ann.
It's good to see you as well. No problem.
Delegate. I co-chair this Family, Youth, and Children Committee, and we brought up a similar issue. And right now, in the Governors Association, it was the Colorado Governor Paulus who was bemoaning the lack of longitudinal data, very generally, but across, certainly with MSDE. So you are really on to something here, and I'm hoping that I can follow up with you and work with you, because I see, I don't want to amend your bill because it's got legs, let's get it done. But this is really, we need this kind of data, not just for the foster kids, but we don't have good longitudinal data for anybody leaving high school. So we really don't know what we're doing right, what we're doing wrong. Blueprint is, we want to, see if that's going to work. How's that going to work? So they have a really good report. Let me send you this report from the Governors Association led by Paulus, because you're onto something that I think two things. One, we don't collect enough data. Two, we do it in disparately weird ways. One category, we look at 3 things. Another group, we look at 5 things. We don't have a consistency. I think that's what you and your people are working on. Is that sort of what you're seeing a lot of this over in the House?
Yes.
Okay.
And yes, for sure. And I would love to work with you on that. Hopefully,
Okay.
we're both back here in the next session to do that work.
That's
and
very
I'll
presumptuous of me, but yes.
Yeah,
if we
well,
happen to be back.
and then this summer, I'll invite you over to my little humble abode on the Susquehanna in your district
Oh, that's good.
for a drink, and we can talk more about
When
this.
mine get rebuilt, because mine burned to the ground, I'll invite you to my little abode. on the
Okay.
Susquehanna.
All right,
thank you.
awesome.
Thank you. And yes, everybody's going to come when I have a new house.
Excellent. Well, Senator West.
And a vote too. No, I'm kidding.
All right.
Thank you all.
very much, Delegate. Thank you very much.
Thank you all very much. Good seeing you.
Thanks, likewise. All right, with that, that'll conclude the hearing for House Bill 1305. We're now going to move on to Delegate Simpson with House Bill 768.
All right. I don't want my crossfire running away, right, Senator West? So, Honorable Chair and Vice Chair and the distinguished members of my sister committee, House Bill 768 ensures that orphaned and disabled children in foster care are eligible for the federal benefits and that they actually receive their Social Security benefits. So we worked with our sponsors, we worked with our cross-file, the Department of Human Services, the advocates to ensure that this bill actually supports our youth and has clear language to support their needs. We worked with them to make sure that we brought down the fiscal note. House Bill 768 stops the Maryland Department of Human Services from holding those funds, those Social Security funds that should go to these children, to compensate the state for caring for them. It ensures that those federal benefits intended for children in state custody are used to directly support their needs and their future stability rather than reimbursing the state expenses. The delay in the implementation, you'll notice, is what has brought down the fiscal note to less than $100,000. For all of these reasons, we respectfully urge a favorable report on 768. And just to note, Senator West does have an amendment to it, which we are agreeable to, which makes it very, very clear that the department may not use the child's benefits to reimburse the state for that cost of the care. Any questions?
Thank you. So are you saying that, thank you for bringing the bill, Delegate. So are you saying that the fiscal note that we're looking here is not correct now?
No, it is not. It should not. I think the revised note should be on the revised.
It's updated today.
Yeah.
I don't know if it's on, it's
I
populated
don't think it's
your
on there. 'Cause
laptop
I
yet,
don't see it, but
I'll make sure you get it. Do you have it? Can you print it?
because if I'm looking at it correctly, but there's also a concern. Do you have any answers, or has it been revised for the concerns that were pointed out by the Department of Human Services about the out-of-care home program or out-of-home care program that would require them? So you're saying that this bill would not go back to pay any of those funds to reimburse the state?
That is correct, but it also does not, so one of the things is in the initial bill would give the children some money while they were in care. And so one of the things that it was revised to do is, because the department doesn't have that capability, that it holds those, it confers those funds until the child would be leaving foster care. So it does provide that, which is good. We haven't been doing that.
Who would be responsible for doing that within there?
They are able to hold the funds, they're just not able to pay it out while they're youth.
Well, if I'm looking at a bill that we did in 2018, House Bill 524, it talks about the different distribution benefits
That is correct.
conserved, right? it says that the remaining benefit amounts were used to reimburse the state for their costs of care. So.
Yeah, and if you
this
look
one-
at the bill, it crosses out so that the money
Well, a lot
is
of the
going to
bill
go to
looks
the
like it was
kids.
struck out, wasn't it?
Yeah, that it would be going to the child. It would be conferred for their care and not reimbursing the state.
Well, I think that's what my question is so this one's going to be contrary to the other bill that was based to set up supplemental security income and other federal benefits on behalf of the youth to conserve those resources until them, and that they got the cost beyond the reimbursed amounts? So we're not going to conserve, we're not going to give any of that back for the cost of care.
Correct.
Back to the state.
It is going to go to the child. These are orphaned and disabled children who are definitely going to be needing this for their duration of their life.
Orphans and disabled children, okay.
Right,
And
that are
then-
receiving social, remember, the Social Security, if they are orphaned, they are receiving Social Security, or if they are disabled, Social Security. So rather than going to the state for their care while they are young, it is going to be there for them, you know.
Do you have any comment on their concern about the projected, with the escalating shortfalls in our own finances in the state of Maryland, that they had concerns about this increased expenditure without
I can tell you that the
sustainable funding?
department's concerns have been taken care of with this bill, because we did where we worked.
DHS's?
DHS's, yes. This was done with, this was done with them.
That's the same one.
We worked together along with Senator West
So
to make
it's-
sure to alleviate those concerns. Their biggest concern, of course, was not being able to hold an account for a child in foster care and pay them out.
But it doesn't seem like that's their biggest concern. It seems like their biggest concern is, and I'm looking at, these are the same numbers I'm looking at, which is just under 400,000 or just over 350, whatever you want to say, a year, that we're now adding a new expenditure without sustainable funding offsets for this expense that we don't, and with the federal policy changes, with the shortfalls that we're facing as a state, I'm just kind of, this doesn't, you're saying this one with the $356,000 a year and the $476,000 a year is the new numbers?
I don't know where you, I don't see what you're looking at. I
In
can
the
see,
fiscal summary, the fiscal note, in 28, it says $476,000.
yes.
Okay, and so that's another $500,000 or, you know, that we've got to come up with, and we're already facing financial shortfalls, is what I'm saying. So there's no way to offset any of this, and their concern is about the shifts in federal policy that are escalating financial or fiscal shortfalls here in our own state, that they have concerns about the increased expenditures without a sustainable funding offset.
When we have spoken to them, they have said they are good with this bill. This is what we crafted together with the delay in implementation, because these kids they're still going to need this care when they leave foster care. They're still going to be orphaned, and they are still disabled.
Understood. Have you seen their letter? It's dated today from Department of Human Services.
We do not have a letter dated today. Like I said, we did work with them. This is how it got passed out of the House, is that we definitely worked together for this bill.
Have we moved yours, Chris?
No.
Okay, thank you.
Thank you. Just a couple of questions. I always just like to comment on this. I think it's a little different position than my buddy seatmate here, who wears the best socks. But I went through 11 foster homes. Now, if I had aged out at age 18 without being adopted, I would have had nothing, right? When we say $400,000 fiscal note, if one who aged out without a home, without anything, all of them, I think the state would end up paying more. Also think that when it comes to a child in foster care aging out, they've been through enough trauma, and they don't want to be without a family anymore. And in my opinion, I think that's, when you divide 400,000, a number of children that we're helping, I think that, and I agree with you, that we help. Because if we help those kids and they get jobs, and they're able to go to a community college and get a job, it's going to be given, their taxes, trust me, as high as they are, they'll be given back to the state as well. So I commend you for this bill, and thank you for making this one of your issues.
It is a companion bill to Griffith's bill. And it is related to, so, the other portion of it, I do have a different bill that is a foster care and the assignment of rights, which is about foster care and going after the families. And the federal government has said that it is costing the state, and it does cost the feds a lot more when we don't actually provide these services or the financial supports to the family. Because as you said, if a child were to age out, and I believe if you look at your testimony, you will see kids who had gone to care, thought that they were going to have, the financial supports to go to college, and come to find out did not, because the money they thought was going to be in their account was actually used to pay back the state instead. So, it is one of those things of when we provide them with that support and that care, that they are able to then sustain themselves. Much as many of our kids who are not in that situation would have that, that support.
Thank you, Delegate, for bringing the bill. I have a question for you, and let me back up for a second. There's something called the Local Government Investment Pool, and that was designed to help lots of little disparate municipalities generally deal with their pension benefits, because separately it was very expensive, but the state agreed to collectively grab the money and invest it wisely for their benefit. Now that's what I want you to know. So I backed down, I thought about this idea of saving this money, and not trying to waylay this bill, but something to think about, see if you'd be interested. It seems to me that if this money, I don't know when the children start receiving it, but it might be worth looking into having this money managed a little better, particularly safely, of course. And I'm not suggesting go into the stock market necessarily, but have a rate of return and not just sit there, because the money could lose value over time. But even a modest savings account might, if we have one that has interest bearing, they're not that generous. Sometimes they're 1%, 2%. So it could lose value, especially when you mention going to college and things like that. But there are savings accounts that, if you're strategic, can get you about 4.5%. There's also might be a way to think about asking the department to talk to the treasurer and the comptroller and those that do the local government investment pool with that real expertise about what would be the best way to conserve the money. But conserve it, in my mind, is not to let it lose value over time. So I throw that out. I don't know if you all have discussed this, if this is somewhere else in the department's workings, but what are your thoughts about that? And are you aware that this may go on already or elsewhere?
No, Senator, that you're bringing up a very good point. There's actually several bills, that I'm the chair of the subcommittee for family law. And some of the issues and some of the discussions that we have actually had with the department is that ability to be able to, what do you do with these funds?
Right.
And whether or not you're able to give them to a child. There's all sorts of laws that restricting. Some of the things we talked about is babies having babies in foster care, right? How do you give child support if they don't have, a supportive family? Right. So I do think that there is a bigger issue.
Right.
And I agree with you. I understand where you're coming from of making that comparison, since my regular day job is the retirement. So it is something that needs to be looked at.
Yeah.
I think for right now, when it comes to this bill, and I understand the note that I just received is actually DHS was not able to make that is not the case on, this is Daniel Cohen from DHS says they weren't allowed to update their letter based on the amendments. And, that's the original bill. That's not this bill. I mean, there have been so many changes being made, and some of the discussions were the original bill was being able to provide some of that money back while the child was under 18. There is not a mechanism for that currently. And we want to make sure that these kids, when they're leaving foster care, whether it's at 18 or 20-something, that they are able to, once they turn 18, they would be able to have access to these funds that are intended for them because they are orphan children or disabled. And as we know, they have a greater cost. So, no, I'm agreeing.
I want us to think about and I'm very familiar with this because I worked on this bill many years ago, this local government investment bill. I want us to think about the fact that the department is not generally in the business of managing money, but the state in other places is.
I know,
expert.
and they do a
So
good
why
job,
don't
too.
So why don't we share our knowledge, expertise, and think strategically about growing this money so that it does not lose value over time? So
I think it's a great work. I do. I agree. It's a great work group,
Yeah.
and we would like to make sure that the finances are managed and accurate for each and every child.
Okay, good. Thank you.
So,
Thank you, Mr. Chair. Not long ago, we passed a bill in this body to spend well over $100 million on a new correctional facility, which at least some of us felt was not essential. By contrast, we're talking here not in the hundreds of millions of dollars, but $400,000. Would you agree with me that if that's the number we're talking about, that the state of Maryland should not balance its budget on the backs of orphans and disabled children for the sake of $400,000?
Yes, especially since I think every single one of us was visited by many individuals from the disability community. And this is one way that we're saying that these kids who are disabled, who are deserving of these finances, and I think even the federal government has been taking another look at how have we been funding our government, and should it be on the backs of our most vulnerable, on our children? And so I would completely agree with you, Senator West. Thank you. And thank you for cross-filing this with me. I definitely think this is a very important issue.
Thank you, Mr. Chair. I just want to give one clarifying statement, because you had made a comment about helping them with college. But MHEC, this body passed legislation that their college they get paid for. So we're already paying for their college. So I just want to clarify that, because it was kind of misleading how you said they would need this for college.
In-state, not every child wants to, they may be going.
You can go to college for free in the state that you grew up in.
You can look at some of the testimony and see some of the kids who were in that situation in which, and it's not just about tuition. We all know that, that college has a lot of other expenses. You got to eat while you're there too.
Thank you.
Thank you.
All right, thank you very much. Further questions from the committee? All right, Delegate Simpson, thank you very much. Thank you. With that,
Thank you.
Excellent. So that'll conclude the hearing for House Bill 768. We're now going to go on to Delegate Holmes with House Bill 402.
Good afternoon. Thank you for having me here, Mr. Chair, Mr. Vice Chair, and honorable members of the JPR and Senator Folden.
Just make sure you see it.
I do appreciate being here. Most of you know that I've spent over 4 decades of my career in this housing industry in one form or another. And what we have before you today is House Bill 402. Now, what the bill does in House Bill 402 is that it creates a common ownership community oversight division with the Department of Housing and Community Development. And we had several discussions with the governor's office in preparation of this piece of legislation. The reason why this bill is in DHCD this time, as opposed to the Attorney General's office as in previous years, is because the Attorney General's office currently has one purpose that they can do for common ownership communities. They can attempt to mediate. If one party or the other does not want to mediate, the Attorney General's office can't do anything else, and therefore there's nothing else for the citizens of the state of Maryland where they can gain assistance. In the state of Maryland, if someone who lives in a condo, HOA, or co-op has a question or a problem, unless you live in Prince George's County, Montgomery County and Prince George's County to a lesser extent, but specifically Montgomery County, there's nowhere to go. If you have a question or concern, most senators, delegates, and persons in the governor's office, their response is the same. Call Marvin. And that is all across the state of Maryland. Now, I don't mind it, and my chief of staff is used to getting phone calls at 3 o'clock in the morning to get assistance, but it's not fair to the citizens of the state of Maryland that there's no state agency in charge of this to get them some assistance. So what we are doing here is we are creating a common ownership community commission in the Department of Housing and Community Development, where everyone in the state of Maryland can go to get some help because they need help. And what we've done in this bill, HB 402, is we have crafted this bill based upon a working model. As I indicated, there are 2 CCOCs in the state. There's one in Montgomery County, there's one in Prince George's County. I am a resident of Prince George's County. I am on the commission for Prince George's County CCOC. I am also the vice chair of the CCOC in Montgomery County for the 2nd year in a row. So I'm very well understand how these CCOCs work. If you have a dispute within the CCOC, as I have created it, you can go to that CCOC and get some assistance. Sometimes people say that getting assistance within a CCOC is not necessary because you can always file a lawsuit. What we are attempting to do with this particular HB 402 is not have persons have to file a lawsuit and get an attorney. Within the existing CCOC structure that I have laid out here in 402, it is modeled after a very well-working model, like indicated, for Montgomery County. You pay $50 and you have your case heard within the Montgomery County CCOC. Within that dispute resolution process, there are 3 panel members that sit as district court in your case. If you want to appeal that decision, you can appeal that case to the circuit court. It works very well. And what we've done is we've created this, and now we also have Baltimore County that has just filed or just put their bill in for 2026 to create their own CCOC. And the model and the language that Baltimore County has used to create their CCOC is based upon what I have given them, which is 402, okay? Now, if a jurisdiction does not want to have their own CCOC, then what happens is that the Department of Housing and Community Development does all of the above that I just discussed. Because there's no place to go to have a resolution with your cases being heard. At the end, like I indicated, the AG's office will only mediate. If either party doesn't want to mediate, they wash their hands of it. That is the bill in a nutshell. And I'm sure that there are a lot of questions, and this bill is being cross-filed with Senator Muse's bill, Senate Bill 981, and we look forward to having both of these come out. And this bill, HB 402, did pass the House, and now we are bringing this bill here for you. And with that, Mr. Chair, I will entertain any and all questions for this wonderful bill.
Excellent. Thank you very much, Delegate. We have questions from the committee. We'll start off with Senator Folden.
Thank you, Mr. Chair. It's always good to see you.
How are you, sir?
Good, sir. How are you?
Good.
Wonderful. So I just want to ask, like, what type of cases are we talking about here? Like, they would range from what to the lowest level to the most severe type of issue that we're trying to solve here?
And that's a very good question. And like my grandfather used to tell me when I was growing up, boy, you got to be more specific with your specificity.
More specific? I got.
And your question is specifically outlined in the legislation in terms of what types of alternative dispute resolution cases will be heard.
So I can look that up?
Yes, it's right. It's right. And it's line by line within the bill.
I appreciate that. Thank you. So that leads me to my next question, which is, does the bill as it's written now, and I'm just, again, looking at the AG's letter, does it still have a requirement for an ombudsman without a funding source?
Good question. In the attorney, let me back up. We changed the name from ombudsman to office of the office of I forget the title of the bill now. Oversight. That's it. Thank you. Oversight. And and because of the way it's written, let me explain this to you.
Is it a funded position now?
But the funding.
Yeah.
And I'm getting very specific with the funding.
Yeah.
And what I'm going to do is read a couple of sentences from the fiscal notation that was sent to the Department of Legislative Services from DHCD to explain exactly how the funding would take place, okay? Because every department that is in a piece of legislation has to submit this information to Legislative Services. So, and this is I'm going to read this so you understand it exactly. The bill states that COC Oversight Division will have a common ownership community ombudsman. This position is to be appointed by DHCD Secretary. And the impact of that, DHCD's OAG team notes that determinations of whether any decisions violate the appropriate state or federal law are decisions that must be made by an attorney, regardless of bar membership requirements to the legislation. As a result, DHCD's Housing Ombudsman, which was an existing department, created within DHCD just this year. They already created an ombudsman unit this year, which is why I had to change the name of the bill to the oversight, okay? Now, that ombudsman unit is what's going to be used to help the DHCD to get the first part of this bill done. And the first part of the bill is there's a reporting requirement for the bill. And the reporting requirement requires $50,004.33, okay? That $50,004.33 will be appropriated by the governor this next fiscal year. After that, there is staffing that's required, and the staffing will be taken care of in the future fiscal years by the funding that's collected. I hope that answers your question.
So is the fiscal note correct then? It's going to be $250,000?
The fiscal note, when I'm reading the fiscal note, it does not clearly indicate what I just read to you, not at all. Because the fiscal note talks about, can't find it here right now.
It's okay. So
But
I just want to be
the
clear,
fiscal note-
like what you're saying is not consistent with what the fiscal note says.
No,
So
no.
who am I supposed to believe when and with all due respect, they're giving me this fiscal note, you're saying you don't interpret it that way?
How about if I do this? How about if I submit to you the information that was the information that DHCD submitted to the Department of Legislative Services on February the 4th, 2026, which explains specifically how DHCD will fund it.
Okay.
How about if I do that?
No, I appreciate it. And my last question should be real quick. Is there any part of this that could be deemed, if these increase, like if there's for these common ownership communities, is there any potential for a pass-through fee for legal counsel, representation, or anything like that to defend the association? Like, is there a potential for any pass-through fees to the tenants of that community?
That is nowhere in the legislation that I have written, nowhere.
No, I'm not saying that you've written it in there. I'm saying, is there a potential that if these certain type of issues keep escalating and they have to have counsel, and then, you know, is there any concern about that?
No.
Okay.
No.
Okay, thank you.
Welcome.
Thank you, Mr. Chair. Good afternoon,
Good
Delegate
afternoon.
Holmes. Thank you so much for being here. If I had a dispute over ground rent, would this bill address that?
Ground rents. Ground rents, yeah, ladies and gentlemen, let me explain to you ground rents. Ground rents were established in the summer of 1634 by King Charles I. I only happen to know that because, well.
You were there? He was a kid.
Thank you.
Thank you. Brief statement and a question. I thank you for the bill. I think it's a very good bill. I plan on voting on this bill when it comes before our committee. Again, you are a master at this, and you've helped so many. So my question is, do you too think it's a good bill?
Oh, it is a wonderful bill. It is super fantastic, yes.
Thank you very much. I look forward to voting for both of these bills.
Thank you. Look forward to your green vote.
And thank you for letting me be a
yes, indeed,
co-sponsor.
Thank you, Mr. Chair. And thank you, Delegate, for bringing this bill. And I just wanted to thank you for all the bills dealing with common ownership communities that you've brought to us over the years. This will probably be my last chance to compliment you, but it's great that you've taken such an interest in this subject because as condos, not so much co-ops, condos and homeowners associations have proliferated during my lifetime, it's clear that they've sort of grown out of control. And you've done your very best to try to establish guidelines and parameters. So congratulations.
Thank you so much.
That said, now I do have some questions about this bill. It seems to me to establish basically a new legal forum to resolve issues. So, I'm looking on page 21 of the bill. It says this new division shall receive and investigate complaints regarding final adverse decisions by a governing body. So what complaints are we talking about? Are we talking about complaints that the governing body has violated Maryland law or Maryland regulations or local regulations? Or are we talking about complaints like the dog is barking too loud in the condo next door and the governing body won't force the condo owner to somehow quiet down their dog? So are we talking about legal complaints or simply more nuisance kinds of complaints that people run into all the time when they're living in common ownership communities?
Thank you, Senator Weston. Great question. The types of things that go to the panel for alternative dispute resolution must be coming from the booklet that I have sent to all of you, okay? All of you have received this booklet, and for 9 years, I send this out every single year so that everyone can be educated on HOAs, condos, and co-ops. what the CCOC or the Common Ownership Division dispute resolution does is only relevant to the law.
Laws. Okay.
The law.
Right.
Dogs barking too loud, as indicated in your example, I don't think that's in the book.
No, I don't think so either. Okay, well, that answers that. That's good information. And we're, in a way, establishing some legislative history here because the bill is not explicit as to what the nature of the complaints would be. So this interchange is helpful. So then I noticed that it says that the county doesn't have a local commission. I think you've told us Montgomery and Prince George's counties are the only ones right now that have local commissions. Then the state division is going to get involved. And so I guess what that means is if somebody in one of my two counties, Baltimore County or Carroll County, has a problem, they would come, would it be located in Annapolis? They would come down to Annapolis to get the problem resolved?
Well, in the case with Baltimore County, as I indicated earlier, their creation of their CCOC is being voted upon soon.
Yeah.
So they are creating their own CCOC. In your other jurisdiction, where they have not yet initiated to create their own CCOC, then they would have to have the dispute resolution within the Department of Housing and Community Development. Now, I'm going to use the Montgomery County example to explain to you how that works in terms of resolving these disputes. As I indicated at the top, there's a 3-member panel. The chair of the panel is an attorney. There's a professional member and there's a residential member of that 3-member panel. I am the professional member on both the Montgomery County and the Prince George's County CCOC. When there's an alternative dispute resolution in Montgomery County, as again, I sit as the professional member of a common ownership community. We have a hearing. The hearings are Zoom or digital. Typically, we'll start the hearing at about 6 o'clock, and depending upon the number of witnesses, it might go to 8 or 9 o'clock, and may have to be resumed at a later point. It's a regular, normal hearing. You raise your hand, you swear to tell the truth, etc. And the hearing takes place like a regular court hearing. You don't have to go anywhere to answer your question. Okay. You can do that digitally.
So it's like a specialized court in a way. One specialized court, if the county doesn't have one of these things, then there'd be one specialized state court which would deal with these issues, which makes some sense. I like the idea of specialized courts. I think we frankly should have more of them. But it would replace, I assume, the district court because under current circumstances, when this is not in existence, these sorts of complaints would most likely be filed in the district court. Would you agree?
In the cases of the common ownership communities, of which this is based upon, that 3-member panel that I discussed to you, that sits as the district court. After the decision is made by that 3-member panel, an appeal can be made to the circuit court.
But what I'm saying is right now, this is not in effect right now. So if I were living in a condo and I had a dispute, I would file my complaint in the district court.
Yes, sir.
So this replaces the district court.
Yes, sir. That is exactly correct.
The last question I have is the filing fee is $100. Do you know what the filing fee is for the district courts? Is this a comparable filing fee or is this higher or lower? Do we know?
I do not know. I haven't been to court in a very long time, so I do not know.
I would think it would be logical if we made it the same.
Yeah.
So
how much does it cost to file a district court? Never got to know.
$44, okay. So maybe we'll want to reduce this to $44.
Well, let me say this though, and I use the Montgomery County as an example. In Montgomery County, if you want to file an alternative dispute resolution, the fee is $50.
Okay, that's close to 44.
Yeah.
Okay, thank you.
Senator James.
I think these cases go most often to circuit court because I certainly have handled a bunch of these cases. So I'm a little confused about that. But what I'm trying to understand, if we pass this, does that then require everyone to start with this process as opposed to going to court. And not that I think I think going to court is expensive, time-consuming, frustrating, even though it's how I make a living. But some people, do want to go to court for various reasons. Does this bill sort of say you start with, you have to start here, almost like with the APA, the Administrative Proceedings Act, there are some areas of the law where you have to start there before you earn the right to get into a judicial court system?
The answer is yes, you do have to start with your CCOC. And then after that, you can, in fact, dismiss yourself from that and hire your own attorney. But
of course, you can appeal, too. I mean, this is,
and you can appeal.
And again, I'll read the bill because I know it's elaborate, and I know you've worked hard on it. The qualifications for the tri-party panel of judges, if you will.
Yes.
Is that spelled out in the bill?
Yes, it is. And like I said, the panel chair must be an attorney.
Okay.
Then there must be a professional member. For example, I have CMC, Certified Manager of Community Associations. I have a association management specialist. I've got 5 different certifications for all this stuff.
Good, okay. And I'm sure it's spelled out how the proceedings unfold, how you present evidence, how you talk to witnesses.
Yes, exactly.
And I'll read
correct.
that later. So then, just to shorten my own questions, I just noticed 2 sets of the concern from the MACO. I think you probably addressed it because I think you've grandfathered the only 2 counties that so far have this, which would be Prince George and Montgomery. And the way I read their suggested amendment, I'm sure you adopted it, but I just want to confirm. The existing entities in any county that have something like this will be grandfathered and continue in existence, right?
That is correct.
Okay.
And if you, that is already in the bill.
Yeah.
And that is on page, I don't remember what page it's on. Mine doesn't have a page number, but what it says here in the bill, the creation of the division does not override, preempt, or dismiss the authority of an existing commission on common ownership communities established by a county or local municipality. That is in the bill.
Perfect. That just want to make sure. And then I didn't get to read in any detail, but I perused the Maryland Building Industry Association, and they just have a number of, I think it's almost like you might want to call them technical amendments, and I know you've greatly altered the bill. So have you worked with them? They have, they have, I don't know, half dozen or more sort of probably good amendments that are technical in nature. Are you familiar with the Maryland Building Industry Association's letter and whatnut? And did you work with them on that?
You mean this guy right here?
Yes,
yes, ma'am.
maybe that guy
I certainly am. And there are a couple of the Building Industry Association amendments that I do agree with, and I'm still looking at some of the other ones.
Okay.
So
you're collaborating.
We're collaborating. That is correct.
All right. Thank you, Mr. Chairman.
Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill. Appreciate that. I think Senator West was bringing up this line of questioning or whatever. So as the impact on these COCs from a fiscal standpoint, the mandatory filing is up to $100 for governing documents and then $25 per amendment. With the additional penalties of up to $500 for noncompliance, has there been any kind of an analysis on the fiscal impact that's going to be created on the HOAs, condo associations, or cooperatives? And then drilling down for the smaller associations that may face difficulties absorbing these costs. Have you done any kind of?
I appreciate the question. There's a couple of different things there. The $100 filing fee for all of the HOAs, condos, and co-ops. Let me start there, if you don't mind. The reason why that's necessary is because you'll see this in another objection or opposition to the bill that says that filing fee or something along those lines is not necessary because HOAs, condos, and co-ops have to file documents with the land records. I totally understand where they're coming from. However, the depositions that they're talking about, the SDET filings that they're talking about, and the land records they're talking about, as a person who created subdivisions and office parks and stadiums in my previous life, I assisted in creating those documents and sending them to the land records and SDET. Every HOA, condo, et cetera, has an annual meeting, and in those meetings, when they have the annual meetings, the bylaws can be amended. The SDET, land records, and all those things that my opposition is going to say why this is not necessary, don't necessarily keep up with all those bylaws. You can't have a dispute if you don't have updated records. That's one part. The other part you talked about was the $100 fee and the $500 penalty. That has not been analyzed in terms of the fiscal implications on the HOAs, condos, and co-ops itself. The reason why the 500 is so high is, again, I am mirroring this document after Montgomery County 10B, which has worked for many years, and because the penalty is $500, everyone participates quickly. And if there's a dispute resolution and those documents are not sent to the COC, you cannot have a proper hearing because you're working off of old documents that are not relevant.
If I may, Mr. Chairman. So you brought up the dispute resolution. So I'm just, how are we going to ensure homeowners' protection? Because you've got in here that it creates a detailed dispute resolution framework, having the mandatory stays, mediation hearings and appeals. And while the bill, how are we going to make sure that the bill doesn't prevent any delays with the required 14-day notice, pause, or the 60-day initial waiting period, and stay for enforcement once the dispute is filed? Are there any concerns about that homeowner protections are still going to be insured through this whole waiting period and delay?
Now, when you say insured, are you specifically talking about the HO6 for condominium insurance, or I'm not sure what you mean by it.
I'm just talking in general. In general, it just seems to me we're creating more of a framework and more bureaucracy that we're not getting to a resolution in a timely fashion. Is there any concern with that?
Yes. Now, sometimes there are a lot of disputes that have been filed. And when a lot of disputes have been filed, there is a provision, maybe it's not specific in this bill, there's a provision that you cannot have a financial resolution unless it is, in fact, resolved at the panel level. I hope that answers your question.
I'll follow up with you.
Oh, thank you.
Thank you, sir.
All right, seeing no further questions, thank you very much, Delegate.
Sure.
All right, so you have some folks scheduled or signed up, one favorable with amendments and then one in opposition. So we're going to have Mr. Enton, who signed up favorable with amendments first, and then we'll hear from Cynthia Kent.
Thank you, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Building Industry Association. You do have our written testimony. It's interesting. This is a 30-page bill with an 11-page fiscal note. And it's 30 pages pretty much of new language. So there's a lot to this, for sure. Out of all this language, we had 5 concerns, and they're listed in our written testimony. I met with the bill's sponsor earlier today, and he's okay with our first 2 recommended amendments. So that leaves 3 that we're still concerned about. This is a big deal. this bill. And, to have this 30-page bill, it impacts us because we're the ones that put these, we're the declarant, we're the ones that put these associations together. And we just want to make sure that if we're going to transition into this new regulatory oversight, if you will, that it's workable, and that we're not unnecessarily duplicating what's already there. So I'm very hopeful that over the next day or two, be able to sit down with Delegate Holmes, who I have a tremendous amount of respect for, and see if we can't work out the remaining 3 issues that are listed in our document. Thank you.
Excellent. Thank you very much. Questions for Mr. Renton? All right, seeing none, thank you very much.
Thank you.
We'll now hear from Cynthia Kent.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Cynthia Hitken. I'm here on behalf of the Maryland Legislative Action Committee for the Community Associations Institute. Like Delegate Holmes, I have been in this business. I am now a retired-ish attorney practicing law for more than 40 years. I am qualified as a technical expert and would answer any questions you might have. Major concerns by the Community Associations Institute. This is a big deal, as Mr. Renton said. It is an oversight bureaucracy that has redundancies with things that are already existing in the HOA Act and the Condo Act. Namely, Secretary of State has the documents, SDAT has the documents, Land Records has the documents, HOA Depository has the documents, and all these governing documents go to every buyer upon the resale of these units or the lots. There's redundancies in mediation. There are local mediators who are available. The Office of the Attorney General provides mediation services, and I respectfully disagree with Delegate Holmes. The Office of the Attorney General is also the enforcer for the state of Maryland if there are violations of the Maryland Condominium Act or the HOA Act. We're not eliminating these redundancies, and I think that is going to be very confusing, overburdensome for many of the communities. Let me stress to you, there are costs to these communities, and you have a fiscal note as to what it is for the state of Maryland. It will also be for the associations. 7,500 associations, 1.1 million Marylanders, of which I am one, who lives in a community association. One of the associations I know has 200 homes. If some of these fees go in, they will have to raise their budget by $2,800, and they should be putting their money in reserves and sticks and bricks. This is administrative. And while some of these goals are very lofty, we have to say this is administrative. We have shortfalls in their budgets, just like the state of Maryland does.
Excellent.
Thank you.
Thank you very much, Ms. Kent. Questions from the committee. Senator James.
I don't know if I have your written testimony, and I apologize if, did you have written testimony?
Yes.
And I'm sorry, give me the name of your entity again. It
is the Maryland Legislative Action Committee for Community Associations Institute, which is a national organization. We note that only nine states have an ombudsman or oversight out of the entire country, only 9 states because of the cost. We also note that only 2 jurisdictions since 1991 have the CCOCs. Again, I would suggest it's because of the costs.
Okay, I'm going to find that testimony. I thank you for coming, and I'll certainly take a look at it. I think what you're saying that rings a little bit true to me is that we may inadvertently, I think this bill sponsor does not want any of this to occur, but if we have redundancy or we have overlap and we have unintended confusion after the bill is passed, where, you know, the AG, is that the right person for this particular issue? Do we go to the new entity? You know, represent a lot of community associations, so I'm well aware of how many documents they have to file and how many places they have to file and how much litigation can come out of it. So I'll look for your testimony, and I assume you're local, and if we want to follow up and ask you more questions, because I don't have your testimony, so I can't really ask you the kind of questions I want to, but I appreciate
am indeed local. I live in Baltimore County.
Very good. Thank you very much. Thank you.
Excellent. Thank you. Further questions from the committee? Seeing none, Ms. Kent, thank you very much.
Thank you all very much.
All right, with that, that'll conclude the hearing for House Bill 402. We'll now go on to House Bill 502 with Delegate Holmes.
Thank you, Mr. Chair and members of the committee. I am still Delegate Marvin Holmes, and I'm here now on HB 502. And HB 502 is a bill that is requiring members of a board to take training. And the reason why this bill is necessary is because a lot of the board members in condos, co-ops, and HOAs just don't know what they don't know. And what this bill is requiring is that they take training. Now, there has been some discussion about the training costing too much, taking too much time, et cetera. And I just wanted to explain to the members of this committee that there is training that is available where it costs nothing. I'll give you a couple of examples. The Montgomery County CCOC has training every second Saturday, and fourth Sunday of the month. And I am one of the trainers. The training takes place from 9 a.m. to 1 p.m. Free. There's also training Prince George's County CCOC. Free. And there's other areas of people that do training with the very small cost. In the training, for example, with the Prince George's County CCOC, it's virtual. And you can pause your training, come back later, pick up where you've left off, and then continue your training. The reason why this training is so necessary is because every single year we convene here in the General Assembly and the laws change. And if you don't keep up with the laws when you are governing an HOA, condo, or co-op, you will be misleading them, particularly when you're responsible for millions of dollars of their funding. And in a nutshell, ladies and gentlemen, that is this bill, and I will take any questions if you'd like.
All right, yes, Senator McKay.
Thank you. Thank you, Delegate, for bringing the bill. So we are talking about volunteer boards, right?
Absolutely correct.
Okay. Like the other bill and this bill, are we concerned about burdensome regulations and that kind of stuff on a volunteer board?
No. And let me explain to you why.
Okay.
It has been shown that when board members take the training, they are more interested and become more advocates for others to take the training because they now know the importance of being trained. We have a lot of very intelligent people in the state of Maryland that are being volunteers to do these kinds of board member issues. However, I'm going to go through this list very quickly. Do they understand the Maryland Co-op Act or the Maryland Homeowners Association Act? Probably no. Part of the training must include roles and responsibilities of common ownership governing bodies, fiduciary duties, responsible government policies, legal structures and guidance, reserve studies and audits, meeting procedures and requirements, handling of disputes, insurance and bonding, community maintenance, record keeping, and state and local resources for governing bodies. Those are the requirements for the training that these board members must take. Because with this type of training, the specifics of this type of training will make them a better leader for their community.
If I may, Mr. Chair, thank you very much. So it imposes a 90-day, for new board elected or appointed members, it imposes a 90-day training deadline. Are they not allowed to vote?
Oh, no.
During that training period, the first 90 days, you got 90 days to get trained.
Yes.
During that 90 days, are they allowed to vote on the board?
Yes.
They are, okay. So, but I believe the bill talks about failure to complete training allows the removal of office or invalidation of vote.
Oh, good point. I'm sorry.
Yeah.
Have you finished?
So how does that work? I've taken my 90 days, a vote goes by, somebody says, wait a minute, you've not been validated for taking the training, your vote is no good. How is that going to be good for a all-volunteer board?
Sure. What I have done is I have, with an amendment, removed that one sentence about removing the board member.
Okay.
I'm sorry, about the invalidation of the vote.
The vote, invalidation.
Okay. Now, in the other portion, I have said that if the board member does not take the training, the other board members, elected officials, may remove that person. May, not shall, may.
Okay, all right. One last of the, thank you very much. So how do these governing bodies then are held accountable for those people who have completed the training, retaining certificates, and in compliance? How, I'm having a common theme here. Volunteer boards, putting a lot of burdens on. So how do you account for completion and certification, registration, and that whole part?
Every time you take training, you get a certificate. That training is maintained, and it's proof that you have taken the training. Now, the other part of your question was about, I think, if someone takes the training and they still do something illogical or irrational, what happens then? That's when you go to these systems of alternative dispute resolution. Anyone in the state can file a lawsuit, can file a complaint with the Attorney General's office. Right now, you can file a complaint with a resident can file a complaint against their board, or they can file a complaint against their property manager. And property managers in the state of Maryland, in order to be a community manager in the state of Maryland, you need one thing: a business card that says you're community manager. That's it. That's a different bill. But if you can file a dispute and with the Attorney General's office, but again, it's mediation mostly with the Attorney General's office, unless you file a lawsuit with the AG's office.
Okay, thank you, sir. Thank you, Mr. Chair.
Of course, Senator James.
Oh, thank you. Oh, I actually very much agree with you, having worked with board members, that they need the education. Here's where I'm struggling just a little bit. I do not know how many hours is involved, but some of the most talented board members I've worked with are very busy people, and I don't know how many hours we have and whether 90 days is reasonable. I might want to give them more time. I'm also not sure, and you may have, evidence or grounding for it to be valid for only 3 years. And what I was thinking about was that some things do change, Delegate, for sure, but some things don't. And it seems to me that what you'd want to do is perhaps have people have to up their training, but not from the entirety of it. If I'm on a board member for 12 years, I'd be darned if I want to sit through governing 101 that I've heard 12 times. I think it's kind of like one of those things where for people that have been gone through the training, you'd maybe want, here's almost like the appendix to the annotated code. Here's what's changed since the last time you were here.
Sure.
As kind of it's like a driver's you know, I've learned how to drive, and let's say there are a few new rules. I don't want to take the whole driving test again. So I'm just suggesting that maybe we could work on, tell me how many hours this is generally, because that might inform me as to how long I think you should have, especially if you had like a percentage of the board had the training. I would be less concerned, like if 60% or 70% already had it, you've got 3 new members, I'm not gonna be a stickler on the 90 days. I might give them a little longer depending on their professional obligations. And I also don't wanna lose talented people who go, oh, heck no, I'm not getting involved in this, because I want those talented people. And then I would just suggest we think about their certificate in 3 years and maybe a way to change the language so that we would be capturing capturing things that have changed in those 3 years, as opposed to having to take the whole training again, especially if it's 30 hours. I don't know what it is, but I would not relish the idea of having to take the same darn training that long, that much, from one end to the other. Does some of that make sense to you?
Yeah, and I certainly would be agreeable to working with you on that.
Okay.
Yes, indeed.
Great, thank you.
I appreciate it.
Thank you.
Any further questions on this bill? All right, thank you.
Thank you, sir.
Delegate Holmes. I stepped out briefly. Was that your last, is this your last bill that we have now completed?
Yes, you will not see me anymore this year. Mr. Chair, please don't cry.
We will miss you. We will likely see you in your committee. All right, well, that concludes the hearing for this bill. Just trying to finish up our landlord and land use bills. If we could have Delegate Stewart next, House Bill 313.
Thank you, Mr. Chair, members of the Judicial Proceedings Committee. My name is Vaughn Stewart, and this is House Bill 313. I appreciate the invitation to the Marvin Holmes Show. It was as enjoyable as it was on my old days on the Environment and Transportation Committee. This bill passed the House in a bipartisan way. It follows along work that this committee did on a bill that Senator Sidnor sponsored a couple of years ago. Y'all might remember there was a bill to prevent shield records, landlord-tenant records, that did not have a disposition that was in favor of the landlord. So the concern was that in some cases, evictions are filed against tenants, then the tenant wins, and yet it was still showing up on case search as a record that was sometimes held against the tenant. The courts have responded to that bill. It's been positive, but there is one loophole that we did not, I didn't consider it personally back then, which is that tenant screening companies are still allowed to use that data. So the bill basically closes that loophole. Right now, that data is shielded on case search, but tenant screening companies use AI software to scrape that data before it's shielded off court records, and then they sell that data to landlords. So even though we have made the public policy decision, whether or not you voted for that bill or not, we made the public policy decision to shield those records, but we did not say that tenant screening companies were forbidden from using that data if they scrape it before it's shielded. So this bill attempts to close that loophole. The good news for the committee is that we worked with all the stakeholders in a really collaborative way, and we've now eliminated with a couple late-breaking amendments that I believe we are either in drafting or have been emailed to the committee. There's no longer any opposition to the bill. So we work with the CDI, the Consumer Data Industry Association, on some amendments. They represent the tenant screening companies. We work with MMHA and the landlords on some amendments to satisfy their concerns. We now have, I think, a consensus product. But just very quickly what the bill does. One, it requires landlords to provide some standard disclosures before they take an application fee from a tenant, because basically we want prospective tenants to know what the screening criteria are before they pay an application fee. Two, it requires, as I mentioned, screening companies to maintain reasonable procedures against disclosing shielded records and to not knowingly disclose them. And then third, it gives tenants the right to dispute inaccurate screening information and seek remedies when their rights are violated. What it does not do, crucially, it doesn't touch credit checks. It doesn't touch lawfully obtained consumer reports. It doesn't touch anything about actual eviction judgments against tenants. And landlords who rely in good faith on third-party screening reports are protected via a safe harbor. So as I mentioned, we've negotiated this carefully. It did receive bipartisan support over in the House. There's no longer any opposition, and I urge a favorable report.
Thank you, Delegate. Senator McKay.
who I did not go to high school with, but my son, with any luck, will graduate from the same high school that Senator McKay and Delegate Kaiser did in like 15 or 18 years or something.
So isn't it true, Delegate, that where you live is very close to where I was positioned as a safety patrol?
Not only is it close, Senator McKay, and I know that I look like a really strong individual, but I could actually throw a football from where my front door to where your safety zone patrol was. And to my knowledge, you left such an indelible mark on that corner that there has not been a safety issue since you were there.
Well, thank you. I appreciate that. Isn't that so?
Thank you, Mr. Senator.
Delegate Stewart, I want to move along, but I do have a question. It's a little bit of a macro question. It's not specific to this bill, but I want to contextualize some of this legislation with other legislation.
Sure.
To describe what I'm concerned about when these things start to add up.
Yep.
So you want to remove certain things off the court records, and I appreciate that you've built a consensus around your legislation. We had legislation earlier this year, may have already passed the House, that would ban the use of credit scores for rentals. When they were testifying on behalf of their bill, they said, well, don't worry about the credit scores, use the criminal background check and the court records. But we also have legislation to ban the criminal background checks. And when they were testifying on behalf of banning the criminal background checks, they said, well, don't use the criminal background checks, use the court records and the credit score. So everyone is saying, take my part off, but use the other ones. What I'm nervous about is that if we do all of them, there will be no record at all, and people won't know who is living in their homes. And when they don't have the opportunity to find out at least nominal information about people that they may rent their property to, they will not rent that property at all. The risk will simply be too high. So I just want to put, it sounds like you've built consensus. This sounds like a great bill to me, but you have people on other legislation saying to rely on the very data that you want to get rid of in order to pass their legislation.
Yeah, and I appreciate you raising it because I think at first blush, it's a very legitimate concern. And I put in landlord-tenant legislation before. I'm generally someone who believes that landlords should have information about tenants. Like, I think that's important. People should know who they're renting their homes to. What I would say about this bill in particular is that we've already made this policy decision. So we're not actually taking anything off court records at all. Those records, thanks to Senator Sidnor's leadership, who's now walked in, that's already been taken off court records. So this is not so much a new policy like maybe some of the other bills that you were wrestling with this session are. This is really a cleanup bill from the good work that Delegate Hill and Senator Sidnor did to basically say that in situations where either the tenant wins a lawsuit or in which it's just, it's dismissed for some other reason, we don't want those types of cases to hang over a tenant's head for years and years and years. But it's just a loophole that's arisen, which is that we took it off the court records, but sometimes that information, that shielded information, there is a time when that's still available. And we're not changing that. We're just saying that if a record has been shielded, we're not going to allow tenant screening companies to basically scrape the data, build their own database, kind of an analog database, and hold these records in perpetuity when we as a body made a decision that those records should be shielded or screened. It's a totally valid concern. I understand that every bill is read in the context of what the committee is doing overall. As someone who used to be on the committee that has housing, I totally get the concern. I will say just on this bill alone, I think it's a relatively small lift and a relatively small step forward to plug a loophole, and that's why both the landlords and the tenant screening industry folks don't have any problem with it.
Great, thank you for that answer. Any further questions for Delegate Stewart? All right, thank you so much, Delegate Stewart.
Thank you, I appreciate it.
I really appreciate it. I see the majority leader is here, and we'll have some fun constitutional law coming up here with your bill, Delegate Moon. House Bill 351, please.
Thank you, Mr. Chair and JPR colleagues. House Bill 351 is very similar to a bill you actually had by Vice Chair Waldstreicher, which would have established a civil remedy for those Marylanders who have faced a violation of their rights in state court. So I know you guys did your own work on the bill. We have that over in judiciary, and I've heard some of the changes that you all have made. And so I guess I just want to focus in on the one part that is not included in the Senate bill that is in the House bill before you, and I think it's been a little bit misunderstood, so hope to be very clear about what that is. But we included in the House version of this bill both that it wasn't just that Maryland residents would have the right to sue for a rights violation, but that the Attorney General would also have the rights to sue for a rights violation. And as part of that, we also opened a very basic procedure whereby a litigant could ask the state to note the complaint of the rights violation and then enable, and this is enabling only, enable law enforcement to attempt to identify the suspect vehicles and officers that were involved in that rights violation. It's enabling only. And I want to be very clear, this is not doxing. There is no publicly released identifying information. But the idea is that we would have very commonly used law enforcement tools, license plate scanners and whatever, that the state already has available at its disposal if in fact what we're dealing with is a criminal complaint against one of these officers. But to bridge into the civil realm and allow at least the state to initiate a process to, again, just to identify cars and vehicles and phones that were at the center of some of these misconduct complaints. They would be only available to litigants under court order. All of the immunities available to litigants still exist in terms of sovereign immunity and individual qualified immunities, and all warrant requirements and other constitutional requirements still exist with this data. It is enabling only, and the reason I ask you to take a second look at whether you might want to include that before we wind out of here on sine die is we do have, in fact, situations where you have a very clear rights violation and agencies that are making public statements that they do not intend to make information available in the court process as is ordinarily done. It's a very unusual circumstance we're confronting, and so it's a little bit of an unusual tool that's being proposed here. It is enabling only, and I do believe, it is my hope that it will never be used. It will never be used, but that we can go home and tell our residents that we actually did something if and only if we encounter a situation with a lawless agent creating a rights violation and an agency that is intentionally going out of their way to make that information not available under the ordinary rules of civil justice.
Great. Questions for Delegate Moon. Senator West.
Thank you, Mr. Chair. So I'm just reading this bill for the first time. So it looks like this only applies to federal law enforcement officers, correct?
No, I wouldn't put it quite that way.
Okay.
It's, and I think you guys phrase it differently. The wording here is judicial officers, but it actually is defined by what powers they have, and it's whether they have the power to arrest for a constitutional or federal law
Right.
violation.
What Maryland law enforcement officers have the right to make an arrest?
Well, if they're
because there's
part of a
violation of
special
the US
joint
code?
task force,
Excuse me?
if they're part of a joint task force, I think you could argue they could be.
Occasionally have a joint task force.
Occasionally.
But 99.9% of the time, this bill is going to apply to federal law enforcement officers, right?
It could, but again, we wrote it specifically not to be specifically about federal officers. And not only that, I would also point out that this is not actually about immigration enforcement either. This is broadly
no, there
about
could be
rights
FBI
violations.
agents.
Yeah,
Could be FBI
ATF, IRS,
Yeah,
whatever.
exactly.
Yeah.
So, well, Other than these joint task forces, I'm not aware of any situation in which a Maryland law enforcement officer, state police, local police, whatever, has the right to make arrests for violation of federal law.
It might be rare, but again, we did not write this bill in any way that would single out federal officers.
Okay, and then, so what it says is if a plaintiff, who I assume alleges that he or she has had his or her constitutional rights violated, files a complaint, the federal officer can, the plaintiff can, if the court says okay, can gain access to cell tower data, cell phone data. So if I've ever sent something in my cell phone, a text or a email message, and that can be recovered, then all of that personal information that I believe is protected under rights of privacy could then be turned over to the plaintiff in the case for use in the plaintiff's case, right?
Well, number one, you would have information that was ordinarily available in discovery. And I think.
What's that?
Well, I mean, if you're in litigation, you might have identifying information readily made available to you. So I don't want to prejudge exactly which information is going to be good to come in and what's not. But it's very important to note there's multiple gates, which is why I say I'll be surprised if this bill is actually used much, if at all. It's enabling only. And the first stage is there has to be a complaint that goes to one of the law enforcement agencies that ordinarily does investigations of this manner anyway. In other words, the Office of State Prosecutor, the Attorney General, or a state's attorney. So that's the first gate. They would basically be exercising prosecutorial discretion to say something serious here has happened, and probably we appear to be having a non-willing partner in some agency that's just not giving us information. Things would have to happen to trigger the Attorney General, the state prosecutor, or a state's attorney to then actually request identifying information. So that's gate number one. Again, I imagine that's going to be very rare. Before any laws like this passed, you did not ordinarily see law enforcement in the business of prosecuting or investigating law enforcement.
Federal law enforcement
Yeah,
officers.
the second gate is, of course, as you noted, that none of this is available to the public. It has to be under a court order. There's a third gate that's not in the bill, but it's discussed in the fiscal note, and that's that we have done nothing to water down or remove any of the other constitutional gates to getting this kind of information. So, for example, if a warrant would already be required for some of these, and in fact they are, for historical data, cell phone data, for example, and GPS data, a warrant may or may not be required. A law enforcement officer in a work vehicle at work may or may not have a right to privacy as to the movements of their work vehicle. It just depends, right? After work hours, you might have a different analysis. So again, all of these constitutional gateways exist, and if there's a warrant requirement in law or by common law, we have done nothing to override that, and you can see that is picked up in the fiscal note.
I love your analogy to gates, because literally in order to deal with this, we have to deal with all the constitutional gates that we're going to have to deal with in connection with the No Kings Act that we passed and we had long floor debate about. So all of those constitutional hurdles have to be surmounted. And then once we get past those hurdles, then we have additional, I use the word hurdles, you use gates, whatever. Then we have the additional gates or hurdles in terms of privacy, and to have to overcome those in order to get this information. And the information would be of 99% of the time federal law enforcement officers, and they're extremely private data involving their cell phone conversations, texts.
Well, again, I don't want to prejudge that. My hope is that the minimum.
Cell phone data. When I use my cell phone, I send texts, I send emails.
I don't want to prejudge what evidence might be relevant, but I think the concern, and again, you guys can feel free to whittle the list down, because I think the concern was simply to know who to sue. I mean, this is one of the things that in some of the other anecdotes that we've seen in the news, you don't even know who to sue. They've taken off. The agency said, we're not going to tell you anything about who is involved there, things of that nature. And again, I don't think we're asking for anything other than what would ordinarily be due to an aggrieved party seeking justice in the ordinary court system.
And let me just conclude by asking the final question, and that is, and all this applies only to these federal officers in 99% of the cases. None of this incredibly intrusive stuff would apply to Maryland law enforcement officers, correct?
Well, again, we haven't written it that way, so I would contest that claim.
I think you did. The only Maryland officers would be part of joint task forces, or if you could find some other respect in which a Maryland officer is entitled to arrest for a violation of federal laws, which I think there are almost none of, if any. I'm not aware of any.
No, things happen.
Okay, thank you.
Further questions for the House Majority Leaders? Senator Sidnor.
Just a quick question. On page 4, lines 15 and 16, it defines a judicial officer and it references the courts article. I'm trying to find it. Is this supposed to be courts and judicial proceedings?
You are testing my, I sadly did not print out the referred page, so I will have to come back to you on that. But I to be fair, I think how we define the scope of who's covered in the bill is going to be something worked out in either, I don't want to call it conference, but as we figure out what bills and vehicles we work on, we'll land somewhere that everybody can agree on as to who the covered individuals ought to be.
And the only reason I mentioned I'm having a difficult time trying to find the reference.
But, I think the intent, if I recall from our conversations, was to get the ordinary, has arrest power, carries a firearm, and in this instance specifically has the power to enforce federal or constitutional law.
Thank you.
Yep.
Yep, I think the Senate version calls it covered officer, same idea. We will pre-conference, and Senator Sidnor is welcome to any pre-conference that may occur here. Speaking of pre-conference, please thank Delegate Charkoudian. I know her bill has been appended to your bill, and so her name's no longer atop it, but obviously much of this is her content.
And I'll also give a shout to the whip in the House side, Delegate Martinez, who had a similar bill, and we actually, I think we adopted the statute of limitation, 5-year statute of limitations that he had in his version as part of our reform package.
That's right, and 5 years is in the Senate bill as well.
Great.
Any last questions for Delegate Moon? Seeing no questions, thank you so much. Appreciate your being here. I see Delegate Forbes right in my view here. Please come on up.
Good afternoon, Mr. Chair, members of the Judicial Proceedings Committees. I'm Delegate Kathy Forbes, and I appreciate the opportunity to provide this testimony in support of HB 1005, the Survivor Reporting Reform Act. This bill requires the Department of Human Services to develop a reporting process for mandatory reporters when they were reporting past abuse from adult survivors. Here's the problem this bill is trying to address. Under Maryland's current mandated reporting requirements, professionals must report suspected incidents of child abuse if the suspected abuse is active and ongoing, happening today, or whether it's being reported by an adult survivor of past abuse. This legislation is meant to deal with reports being made on behalf of adult survivors and was drafted at the suggestion of a group of clinicians who feel the current mandatory reporting for adult survivors can be chilling to their therapeutic relationships, cause additional trauma for survivors, and is fraught with inconsistencies. When individuals are abused and neglected, their power, control, and autonomy are taken away from them. When adult survivors make the brave decision to seek therapy, they are met with the unfortunate news in their very first session when they are told by the therapist will have to break confidentiality and file a report if they provide identifiable information about past suspected child abuse or neglect. It doesn't matter if the survivor does not want to report this incident or even if the alleged abuser is dead. the report must be made. The current mandated reporting requires the same form for reporting whether the incident is current and happening today or happened decades ago. And in my testimony, I've linked to the report, the DHR SSA 180 form that must be completed. This form does not distinguish between active abuse and past abuse. It asks questions adult survivors may not be able to answer, and awkward things like name of the child. These survivors are adults. Mandatory reporters are currently required to do both an oral report as soon as possible and written reports within 48 hours. Complicating it further, each county has a different process. Current guidelines say that mandated reporters must contact the local offices. When it comes to adult survivors, the question becomes, where is the local office? Is it the office where the survivor lives now, or is it the office where they lived when the abuse occurred? It's unclear to therapists where to report alleged abuse of a survivor if it occurred in another state. These therapists must obey the mandatory reporting law or risk their credentials, as Maryland has criminalized mandatory reporters who fail to report abuse. One therapist shared that CPS in Baltimore City is no longer accepting survivor reports. And when, in her attempt to be compliant with our law, she said she is mandated to make an oral report, CPS suggested she call 911. Of course, she knew that reporting past child abuse of someone who is now an adult was not a 911 emergency. But I share this story to illustrate how difficult the process can be for these mandatory reporters. What we're hoping to do with the bill before you today is to have DHS collaborate with interested persons, survivors, practitioners, local departments, law enforcement, and state's attorneys to create a reporting system that is more sensitive to survivors, more useful to those receiving the information, and provides clarity to the practitioners about where the report should be filed. There was no testimony submitted in opposition of HB 1005, and more importantly, it's supported by MCASA, the Maryland Psychological Association, and the Maryland chapter of the National Association of Social Workers. The current system is well-intentioned, as no one wants child abuse to go unreported. But the current system is designed for active abuse situations and is unintentionally causing harm to adult survivors of child abuse. On behalf of these adults and the professionals who care for them, I ask for a favorable report. Thank you.
All right, thank you very much. Questions from the committee? All right, Delegate Forbes, great. There
Thank
you go.
There is no cross-file, so I really do ask for a favorable report. Thank you.
I appreciate it, thanks. All right, with that, that will end the hearing for House Bill 1005. And we'll now move on to have Delegate Guyton is next.
Thank you so much, Mr. Chair, Mr. Vice Chair, friends on JPR. Nice to see you again, 2 days in a row. You may see me again before this next week is over. Delegate Michelle Guyton, for the record, District 42B in Baltimore County, and I'm here to ask for your respectfully to ask for your consideration of House Bill 1383. And I hope I don't lose my voice because allergies are very, very difficult today. So this bill simply tells DHS and the judiciary system that when we are dealing with children in need of assistance, permanency plans, guardian hearings, that the children we are dealing with are very, very unique, and so they do not all fit into the same mold. Current regulations say that they have to look at the individual needs of the child, but those needs are not actually spelled out, and so that's what this bill does. It helps ensure that permanency planning focuses on things like health, education, safety, emotional support, and stability, especially so that outcomes and not just timelines define success in this process. And I know I might be the only person in this room right now who's not an attorney, but I have been in these hearings outside of this life, in my other life, and I have sat in particularly review hearings where we've had amazing caseworkers who have done everything possible to get the child into a situation that is safe and has stability, but it's taken a little bit too long according to the department. And that caseworker has been pushed to really move things forward before things were in place. And a lot of those things that were not taken into account in some of these hearings are in this bill. The bill also recognizes that foster youth and transition, in particular, those who are about, and I think I heard earlier, maybe a senator in this room speaking about transitioning from that system, need special help to make sure that they're ready for that, right? And those things require attention to the availability of identification documents, to stable. Thank you. I wish that would solve the problem, but you're very, very kind. Training, education, maybe they don't want to go to higher education, maybe they do, maybe they want to go into training programs. They're going to need basic identification, driver's license, things like that in order to actually succeed after their lives in foster care or as wards of the state. So too many young people face unnecessary barriers the minute that they exit care. They're more likely to be homeless, they're more likely to need services later on. So we feel that by strengthening accountability in this system and focusing on the child's well-being and preparation, that this bill helps us get there. So I do want to point out that House Bill 1383 passed unanimously in the House, and address the fact that DHS did have an informational testimony that I'm sure you all have seen on this bill. And while requesting 4 new positions to make sure that they look at the important unique needs of the child as required by this legislation, they also say that this bill duplicates what they're already doing. So not both of those things can be true. And I want to bring that to your attention. This is the right thing to do for children who are wards of the state, for children that we're about to set up on their own and hopefully will be successful. And it's something they should already be doing at DHS. Judiciary says, however, that they will need no extra resources to put this into play. Excuse me. So with that, I will ask for a favorable report on 1383. And again, I apologize for my voice almost being gone. Sure.
Thank you.
Excuse me.
You all right?
I'm as all right as I'm going to be today. Thank you, Senator. And I do not believe that I'm contagious, but I appreciate.
That's not our men.
I know. You're probably safe at that distance, though.
But the current language of the, I guess the statute says, including the child's health, education, safety, and preparation for independence. Yours, it strikes health, education, safety, and preparation, and then creates the larger list. And so what I was curious, I'm assuming the word including, and to date, has it been interpreted to limit amongst those 4 things, health, education, safety, and preparation, or was it kind of an including but not limited to? Because I guess what I'm trying to understand is yours is more exhaustive, but if including is being interpreted to just those things that are listed, I'm wondering, could it be interpreted to say now we're just going to do the 9 things that are mentioned and nothing more?
Sure. I don't believe that because the needs of the child are already in statute that they're supposed to be looking at them. I don't believe that I would read it that way, or that it's been interpreted to be a complete exhaustive list. But what we do see is that the needs that we would, not we, but the folks who put this together and those of us who work in the system believe are very, very important in trying to provide assistance to these children and get them the right permanent placement, are listed in here. I'm not sure what's left out because we do still have health, medical, dental, educational needs, which safety, emotional stability, timeliness of therapeutic referrals, and And that is something that I have seen actually in review hearings that has become a problem, is that perhaps the placement, the foster care, the kinship care provider may, or if they're aging out, right, they may not have those things in place and they may be resistant to doing those. That's something that comes up a lot. We'd like for that to be considered when these kids are going into placement, socialization needs, enrollment, and extracurricular activities.
So it is a thing that we're
So yes,
listing.
all of these
We're
things are
listing
in.
it because everybody's not getting this stuff or the.
Correct.
Okay.
Correct.
Thank you.
Sorry. I think I over-explained, and it's late in the day, but I apologize for that. Yeah.
And thank you for caring. Thank you for putting in a bill.
Thank you, sir.
You're welcome.
Best question of the day.
All right. Seeing no further questions.
I apologize.
Thank you very much,
All
Delegate.
right, thank you.
All right, that'll end the hearing for House Bill 1383. We'll now move on to Delegate Terrasa. Are you also here for the Howard County Senators as well, or are you just here for? No. Okay, so House Bill 405.
Thank you, Chair Smith, Vice Chair Waldstreicher, and members of the committee. For the record, I'm Delegate Jen Terrasa, here to present HB 405, which ensures that homeowners associations and condo boards are permitted to install EV charging equipment for the use of multiple owners. This is a bill I've worked on since 2023, and it's been modified to address the concerns that we heard. So here's the background. EVs are more common than ever in Maryland, largely thanks to our state's ambitious climate and clean energy goals. And for a variety of reasons, most people do the majority of their charging at home. And so at-home charging is more feasible for those in single-family homes. You have the option of plugging into regular outlet, investing in fast charging, plugging in outside in an outside outlet. If you don't have a garage or a driveway, charging can be much more complicated. Installing your own charging station in a dedicated space can be very expensive. That's why several years ago we passed legislation requiring the government bodies of HOAs and condo associations to approve unit owners' requests to install EV charging. But again, that's really expensive. Ideally, what will happen is your HOA or condo association would install several communal charging stations in unassigned parking spaces. And the good news is more and more community associations are willing and interested in doing this. So what's the problem? Recently, HOA and condo boards have been advised by their attorneys against installing EV charging in communal spaces. The attorneys interpret standard language and community governing documents to require the approval of all unit owners in order to do this, including all mortgagees, which is really virtually impossible. You may as well just say you can't do it. I'm not sure I agree with that assessment. The concern seems to stem from the idea that the governing documents may prohibit installation in common areas for things that not everyone can use. However, I see this as really analogous to a playground. Anybody can use one, but really you can only use one if you have a child who is able to play in it. Just like not everyone can use the EV charging, but it's available to everyone and anyone can get an EV. And use that. So what the bill does is to address these challenges, HB 405 ensures that nothing in the governing documents can prohibit installing communal charging stations in an unassigned parking space. In response to concerns from stakeholders, we amended the bill on the House side to clarify that a board decision to install communal charging stations is still subject to the same budgetary process as the projects of similar size and magnitude. And I did see the Montgomery County Department of Housing and Community Affairs favorable with the amendment and their comment. I spoke with them today, and while I think they'd prefer some additional language with clarifying language, they are comfortable based on the House amendment. They're comfortable moving forward with that. So I have DLS drafting something in case you want a little bit more clarifying language, but I'm fairly certain that the language we put in on the House side covers that. So when HOA and condo boards are willing to work with their community members to install communal EV charging, they really should be allowed to do so. EV vehicles are part of our climate-friendly transportation future, and EVs and their charging equipment must be accessible to all Marylanders, regardless of the type of housing they live in. I respectfully urge a favorable report on HB 405.
Excellent. All right. Thank you very much, Delegate. Questions from the committee? All right, Senator McKay.
For bringing the bill. Much appreciated. So these charging stations, so the condominium, they put them in. Is there any prohibiting the condominium from not allowing non-electric vehicles to park there? Will there be a
So local laws, most of the time, the local laws will specify, I can't remember if we have a state law too, but a local law usually prohibits putting a non-electric vehicle in those spaces.
Okay, all right.
But nothing in here affects that one way or another.
Okay, all right, thank you.
Excellent. Thank you. Further questions from the committee? Senator James has a question.
Can I just add to?
Sure.
Just to add to that, we did put in a clause last year or the year before, I'm not sure, but it's in there, that basically says that they have to consider the adequacy of parking when doing this. So that,
I can tell you the frustration of going to a parking lot that has already, rightfully so, handicap parking, and then having all these EV stations and not being used, and then somebody who may not be as affluent to afford an EV or may not necessarily agree with an EV, then having to walk 2 or 3, I'm going to exaggerate, blocks. I'll give you a good example. Around here for the hotel I'm staying for the 90-day session. In the evening, it's very hard to find a parking spot. And when I see an EV station not being used, and I see EVs using the regular parking spots, it's very, very disheartening. And as we're trying to be inclusive of everybody, but we're not. I know that's not this bill, and I appreciate
no, I hear you. I appreciate that.
It is a frustration beyond frustration.
Lack of parking can be a big issue.
All right. Seeing no further questions, thank you very much. Oh, sorry, Senator. Sorry, my apologies. Senator James. No, the light wasn't on. The light wasn't on. I forgot.
Oh, well, it's so good to see you. How
Good to
are
see
you?
you, too.
I hope your mother's doing well, too. Sorry, I was over there eating. I don't have your bill in front of me, but here was my couple just quick questions. I first thought that the lawyers, because I do represent condominium, the lawyers may have been worried about just the idea. I don't know if this is how the bill is drafted, but if this is something that's voted on and or it's a cost that goes across all the condominium owners, is that how it's, yet only a fraction of them can use it? I'm sure the lawyers have a problem with that. So there's just an unfairness, and there's more than just unfairness, there's a real legality to it, even if we Bigfoot ourselves into it. And it might work really well in a community where there's a lot of EVs. And then it might be really very unfair. Just imagine you're at a condominium and there's one person and there's 100 other residents, and that one person, gets a station and nobody else can use it. So I don't know if you would share, you may not even have had this, but maybe what the lawyers said about, the potential for passing on costs for a fraction of the, participants or people that live in those communities, and how usually you want a common assessment for a universally common asset or something like that. What are your thoughts?
So first of all, I'm happy to share the information that we have. I think what I have is only from one community association, but I've certainly heard that from others.
Right.
And what I would say is it's like any other amenity, that it's like a playground. We certainly put playgrounds in communities that not everybody can use. If you don't have any kids in your house, you can't
still use it, though. I certainly can go to a playground, whether I have children or not.
Depending on the age limitations on it, yeah.
I certainly have.
I like a good playground. But now I'm trying to remember the rest of your question.
Sorry. We were just talking about amenities that may not be.
Oh, okay.
But as long as they're available and can be used, whether the choice is not to use one thing. If you cannot use it because you simply do not have something to use it with, there's a little bit of a difference that I think, I'm just saying lawyers probably pick that up and they're a little bit worried.
Thank you for reminding me about that. So what I would say is we do have language in there that we amended on in the House that says that it has to be subject to the budgetary process that you'd have for any larger item like that. So if your community association lets, the majority of folks weigh in, they would still be able to weigh in. It's just a matter of not having to have 100% of the community plus all the mortgagees.
That's why I wanted
Right.
to see that, what you were.
Yeah, I'm
doing,
happy to-
because
I'm happy to
usually
show you this,
We
but-
do have a certain element, I don't know if it's 70, we've lowered it occasionally for green energy, which I don't agree with at all, but we generally have a threshold that's not 51%, but it's also not 100%.
Right.
That's why I'm struggling, that's why I didn't even share.
So that whatever that is would stay the case. They just can't require 100%
And that's
of
why I'd like
the.
to see whatever you're looking
Sure,
at. where it
I'm
said
happy to share that with
Thank
you.
you. Thank
We'll
you,
send
Mr.
that.
Chairman.
You
Thank
can
you,
send that.
Delegate.
So further questions from the committee? All right, thank you very much. With that, that'll end the hearing.
Thank you so much.
Thank you for House Bill 405. And we're going to go on to House Bill 1272. And Delegate Woods, you're next. And then, is anyone here for House Bill 281? Okay, that's right. And then what about for House Bill 1003? Okay.
Good evening, members of the Senate Judicial Proceedings Committee. For the record, I'm Delegate Gabriel Severa here to present House Bill 1272, which essentially strengthens Maryland's kinship care system by ensuring that when children are placed outside of their home, local departments consider the child's own feelings and views about a prospective kinship caregiver. The bill also clarifies that kinship caregivers must include not only relatives, but also trusted adults with a strong family or other significant bond with the child, including an individual identified by the child or the child's parents. Kinship placements are widely recognized as the most stable and supportive option for children who cannot safely stay with their parents. Children placed with relatives or trusted adults experience fewer placement disruptions, maintain stronger connections to their community, and often have better long-term emotional outcomes when children placed with non-relative foster care. However, current practice doesn't always ensure that children are meaningfully listened to in these decisions, hence House Bill 1272, which makes a simple but important improvement. It requires the child's perspective to be considered when selecting a placement that is truly in their best interests. House Bill 1272 also provides clearer guidance for local departments when approving kinship caregivers by requiring consideration of factors such as 1, the individual's knowledge and understanding of the safety concerns that led to the child's placement, 2, prior involvement in helping or protecting the child from abuse or maltreatment, 3, current ability to protect the child and to understand the child's needs for protection, including willingness to cooperate with the local department. 4, whether there have been previous or current allegations of abuse or neglect against the individual, willingness to abide by court orders, and 5, willingness to cooperate with the child's parents and facilitate contact as ordered by the court and guided by the safety plan. House Bill 1272 simply reflects the basic truth that children are not just subjects of the system. They are individuals with voices, relationships, and a sense of safety that must be respected. By prioritizing stable connections and listening to children in placement decisions, Maryland can reduce trauma, strengthen permanency, and improve outcomes for young people in out-of-home care. House Bill 1272 which essentially addresses not just the concerns that I mentioned, but takes into consideration the child's own feelings, would not just address that, but help to ensure that our kids, when placed in out-of-home placement, that their concerns, their feelings are certainly considered. And so it is for those reasons that I urge this committee to issue a favorable report on House Bill 1272, which I would note passed the House unanimously. And we're really, really, really proud of not just the work product and all the amendments that went into this, but truly believe that this is something that could help kids, particularly those in out-of-home placement care. And so with that, I'm happy to answer any questions.
Thank you, Mr. Chair. Thank you, Delegate, for bringing a good bill. Appreciate that. So my question is, as we're trying to figure out this decision-making for the placement, how do you envision the local departments to take in consideration those very, very, very young children, as well as maybe those who are communication challenged?
Very important question, Senator, if you would. I'd direct that to my good friend and colleague who I've been working with on this bill from the the organization MPMC, Diana Phillips, to protect Maryland's children. I'm sure she'll be able to, follow up and answer that question
That'd be great.
for you.
Thank you. Look
Appreciate
forward to
that,
it.
Senator McKay. Thanks so
Excellent.
much.
Further questions from the Senator Fulton?
Thank you, Mr. Chair. Thank you for the bill, Delegate. Did you address the concerns that in the reprint that were expressed by DHS?
We did, from what I understand, yes.
From what you understand they were, or?
Yep, the House version.
Okay. All right, thank you.
I was going to ask, the person that you referenced, are they here today?
She is, yes.
Is it okay? Because I'm curious what the answer is. Thank you.
And this was Senator McKay's question, correct?
Right.
Taking into consideration those kids that are too young or may have some challenge as far as like communicating.
Thank you.
I do not know the answer to that question, but I can get back to you from the people that helped generate this bill with us, from the Coalition to Protect Maryland's Children.
Okay, thank you.
Sorry.
No further questions. Thank you very much. All right. With that, that'll conclude the hearing for House Bill 1272. We'll now move on to Delegate Woods with House Bill 1290.
Good afternoon, Chair Smith, Vice Chair Wall-Striker, and members of the Judicial Proceedings Committee. For the record, I am Delegate Jamila Woods, Legislative District 26 in Prince George's County, Maryland, and I am here to respectfully request a favorable report on House Bill 1290. This bill is rooted in a simple idea. Children should not be invisible in proceedings that help determine their lives. House Bill 1290 ensures that a child in a SENA, child in need of assistance proceeding, can be present at their hearing where appropriate, while allowing the court to make a determination if that presence is not in the child's best interest. It also requires the court to consider less restrictive alternatives before excluding a child, such as remote participation or trauma-informed supports. So this bill strikes a balance. It basically does not force participation, and it does not override professional judgment. It simply shifts the default toward inclusion while preserving the court's ability to protect the child when necessary. I grew up in foster care and experienced multiple forms of abuse. Those forms of abuse were not the abuse that took place in the family that caused me to go into foster care. Many of those forms of abuse took place while I was in foster care. And I never had the opportunity to share with any system, because I was not permitted to come to court, about some of the literal atrocities that took place while I was in foster care. And so I believe for many children in the system, the courtroom is where decisions are made about their placement, their safety, and their future. And too often those decisions happen without the child even being in the room. This bill ensures that when a child wants to be present, they are given that opportunity, and when they can be present, that decision is made thoughtfully, intentionally, and on the record. My input should have mattered. Other young people's input should matter. This is about fairness, it's about dignity, and it's about making sure that children are not removed from conversations that directly impact them. For these reasons, I respectfully urge a favorable report on House Bill 1290. Thank you so much.
Well, Delegate, thank you very much for your presentation and sharing your background.
Thank you, sir.
We're going to go on with Senator Fulton and Senator McKay.
Thank you for bringing the bill.
Thank you, sir.
Does your bill address the duplicative issues pointed out by the judiciary?
Yes, sir. We actually struck a lot of the language from the bill, specifically because of the concerns that they outlined.
Of the duplicative part? Okay.
Yes, sir.
All right. Thank you. Good bill.
My pleasure.
Thank you, Mr. Chair. Thank you for bringing a good bill.
Thank you,
Appreciate it
sir.
there, Delegate. So does your bill talk about any of the criteria or guidance where attorneys will use to determine when it is appropriate to request the waiver?
So what we The bill, I don't know, doesn't specifically outline that, but what we had talked about being used as therapeutic services, we want to make sure that the child would not be in any form of danger. And that's why and you heard me in the language we talked about having a child maybe participate by Zoom. And if it's determined that it's not in the best interest of the child to participate, i.e. it could have mental health or other impacts on the child, that would be a reason for getting the attorney getting a waiver.
I was going to say, I'm not sure that, I don't want to mess your bill and getting it going through, but we may have to tighten down in future of what exactly that guidance is and to help attorneys understand the criteria and guidance. So thank you.
Thank you.
All right, seeing no further questions, thank you.
Thank you so much.
Thanks for hanging in there with us. All right, with that, that will end the hearing for House Bill 1290. We'll now move on to House Bill 281.
Good afternoon, Chair, Vice Chair, and committee members. I am Catherine Call with Government Affairs for the Department of Public Safety and Correctional Services. I am here today in support of our departmental bill, HB 281, that will ensure that the state continues to access national background checks for individuals who care for and supervise children. As you may recall, in 2023, we appeared before this committee on legislation that brought us into compliance with federal requirements. And since the passage of that legislation, we have been in discussion with the FBI to ensure that Maryland remains in compliance with those requirements. This year's bill is the result of those discussions. It makes clarifying changes expressed by the FBI to explicitly state that only designated governmental agencies receive a national background check and private entities receive a state background check. We do have an amendment that has been submitted to committee counsel at the request of the FBI. It just substitutes one word for another, so hopefully that won't hold up the bill. The FBI has given us another grace period until the end of the year to get these changes made. Otherwise, national fingerprint checks for the state will be denied. So with that, I urge a favorable report on House Bill 281.
Just a quick question. We've had some issues in our school system related to criminal background checks, and so I've learned a little more about how they handle things. As a department, how do you handle discretionary offenses where it doesn't disqualify someone from getting a job within the department, but nonetheless, it makes you think twice about whether this person is the right fit? So I understand that's not the direct subject of the bill, but just briefly, how do you handle kind of discretionary offenses?
That is a very good question, Vice Chair, and I will have to get back to you on that and see how that is resolved.
Excellent. All right, seeing no further questions, thank you very much. Thanks for hanging in there with us.
Sure, thank you so much.
All right, with that, that'll conclude the hearing for House Bill 281. Senator Lamb, are you here for the Howard County? Hi. I wish I knew that earlier, so my apologies. Come on up with Senate Bill 1003.
It's good, all good? All right, we'll keep this short. So thank you, Mr. Chair, members of the Senate Judicial Proceedings Committee, here to introduce Senate Bill 1003 as the Senate Chair of the Howard County Delegation. This bill simply updates the salaries of the Howard County Sheriff and the Howard County State's Attorney's Office, the State's Attorney, to match their growing workload locally here in Howard County. It ties the sheriff to the salary of the police chief, and it also rebases the state's attorney's salary, and then uses the district court judge salary for future increases. And that is the bill. It has, this originated from the House. They passed it already through their delegation. We have a letter of support from the Howard County Senate delegation as well. That's the bill. And ask for a favorable report on this local bill.
Excellent. Thank you very much, Senator. Seeing no questions from the committee, that will conclude the hearings for the day. Remember, we have voting tomorrow at 9 a.m., and we have the floor at 11, and then hearings after that. All right, see you all. Have a good night.
You guys need something to do?